Gopalan. I'm the program manager with the Immigration Department, and I will be the host for today's webinar. We are extremely excited for our first ever webinar from the Immigration Department. And our immigration team is always dedicated to providing strategic and compliant immigration solutions. Our team structure encompasses of immigration attorneys who are supported by senior case managers based out of United States, junior case managers who are offshore based, and our HR specialists who are spread across different locations in the US as well. As our email would have already given you all a broad perspective into today's webinar topic related to immigrant visas, which encompasses of EB1A, extraordinary ability, EB1C, multinational managers, EB2, national interest waiver. Under each of these subsections, we will broadly cover the definition and eligibility, documentation and evidence, application process, and best practices. I am delighted to introduce our two immigration attorneys who will be leading today's session. First, we have attorney Liliana Torres, a licensed attorney from the state of Alabama with over 9 years of experience in immigration law. And Liliana is bilingual in English and Spanish and also conversational in Portuguese. She has a successful track record of handling a wide variety of immigration cases, including both non-immigrant and immigrant petitions. Her expertise lies in ensuring compliance and mitigating risk through the immigration process. Joining her is attorney Olivia Chen, licensed in both New York and Washington, D.C., with over 9 years of work experience in immigration law. Ms. Chen is fluent in English and Mandarin, bringing a unique perspective to her work. She's particularly known for her high success rate in employment-based visa petitions, including EB visas, and her focus on legal compliance and reducing client risk. Together, these accomplished attorneys bring a wealth of knowledge and expertise to the table, making them perfect guide for today's webinar. Please join us in welcoming Liliana Torres and Olivia Chen. Over to you, team.
Hello, everyone. Let's begin with the EB1C category for multinational managers or executives. To qualify for an EB1C, the beneficiary must meet these criteria. First, the qualifying foreign employment requirement. The beneficiary must have worked for at least 1 year in the past 3 years in a managerial or executive role for the same company or an affiliate. Second, the U.S. position must also be managerial or executive. Third, the U.S. employer must have a parent, subsidiary, or affiliate relationship with the foreign company. If the beneficiary is already in the United States, the 1 year requirement applies to the 3 years before their most recent local entry. Now, what does managerial or executive capacity mean for immigration purposes? Let's break it down. A manager directs an organization, department, or function, supervises others, oversees daily operations, and makes personal decisions like hiring and firing. Examples of managerial roles in the IT industry could include positions like IT director, IT operations manager, program director, or IT information security director. An executive, on the other hand, operates at a higher strategic level. They direct an entire organization or major function, set goals, exercise discretion, and work with minimal oversight. Some examples of executive roles include Chief Information Officer, Chief Technology Officer, and Vice President of Information Technology. To meet these requirements for managerial or executive capacity, the application needs to include clear and compelling evidence. Here is what's typically required. Detailed job description, listing the managerial or executive duties, organizational charts identifying his or her position and reporting structure. The team overview must include their job description and qualifications, proof of employment, including payroll records, contracts, and evidence of decision-making authority, such as signed agreements, budgets, and key reports. Now let's debunk a few myths about EB1C. Myth: you must enter on an L1A visa. Fact, L1A is common, but it's not required. Myth, you must currently hold an L1A visa in the United States. Fact, EB1C does not require the applicant to be in the US or hold any specific visa. Myth, the EB1C petition must be filed in the United States. Fact, the petition can be filed while the applicant is outside the United States. Myth, only large companies qualify. Fact, companies of any size can qualify if they meet the criteria. The advantages of EB1C include no labor certification is required, a priority date advantage, a direct green card path, no degree requirement, and eligibility for spouses and minor children under 21. The petition can be filed while the applicant is outside the United States. Thank you. I'll now hand it over to Olivia.
Hi, everyone. I will be talking about EB1A category for non-citizens of extraordinary ability. This category is designed for people who is on the top of their field in science, art, education, business, or athletics. So for the EB1A, you will need to satisfy either one-time achievements, such as Oscar, Olympic medal, or you will need to satisfy 3 out of 10 criteria. There are 10 criteria I'm going to introduce to you. Number one, lesser national or internationally recognized award. The second one, membership which demand outstanding achievement. The third one, published material about you in professional or major media. Number 4, judge the work of others. Number 5, original scientific, scholarly, artistic, athletics, or business-related contribution of major significance. Number 6, authorship of scholarly articles. Number 7, work has been displayed in artistic exhibitions or showcase. Number 8, leading or critical role in distinguished organizations. Number 9, you have a high salary. Number 10, you have commercial successes in the performing arts. For examples, there are several criteria that may be suitable for IT professionals. I'm going to go into some examples for each of the criteria. First, publish research articles. So some IT professionals, they publish research articles or manuscripts in professional journals. The second, for the original contribution, it can be including patented products that have been used by others or have been commercialized. For the membership, some membership in IEEE or other IT associations may be satisfied for this category. For the judge, if you're an IT professional and then you are the judge for the IT competition, or you review the manuscripts or papers submitted from your peers for the paper publication. Number 5, you have earned high salary in comparison to others in the same IT occupation. Number 6, if there are published materials about you and your work. Number 7, you occupy a leading or a critical position in a distinguished IT firm. So for the EB1A, there are several advantages. First, the priority date is more recent comparing to other EB categories. Second, the self-petition is allowed, meaning it doesn't require employer sponsorship. Number 3, the EB1A can be filed under premium processing, so you will get a response from the USCIS within 15 calendar days. For the next category, I'm going to introduce about the EB2NIW. EB2 NIW is for a person's endeavor that is in the United States who has national importance. So the USCIS will waive the labor certification process. There are two separate parts for this application. Just for the EB2, you will need to satisfy the first two basic requirements. For the EB2, you will either have the first one, an advanced degree, or you have a bachelor's degree plus 5 years of progressive experience in the field. Or if you don't have an advanced degree or 5 years of experience and a bachelor's degree, you will need to prove that you have the exceptional ability by satisfying 3 out of the following 7 requirements. Number 1, official academic record. Number 2, 10 years of full-time experience. Number 3, a license or certificate to practice your profession. Number 4, high salary. Number 5, membership in associations. Number 6, achievement or contributions. Number 7, other comparable evidence. So if you pass the first test, the first requirement, EB2, education or exceptional ability requirement. The second one will be the national interest waiver. This national interest waiver is to waive the labor certification process. To satisfy the waiver, you will have to pass the 3-prong test. The first one, it is for national importance and substantial merits. So your proposed endeavor, the work you're gonna implement in the US need to have a national importance. So for example, for the IT professionals, probably you will develop a software for public health, monitoring systems which has been used by US government and hospitals to serve 2 million households. Another example, you will upgrade or create the key components of the cybersecurity system that has been used by US military and DHS. For the R&D, maybe there's a specific patented module or system created by you that have been used by major US banks for the financial transactions. This is the prompt 1. The second prompt will be to prove that you are well positioned to advance your proposed endeavor. In this requirement, you will need to prove that you have a degree, your previous projects, your awards, achievement, patents, products, or applications for your past endeavor. The last one will be the balance test. For the balance test, you have to convince the US government that your entry is beneficial to the nation and it will not affect the labor market because, for example, your work has the urgency, very urgent to serve the household or the patients for the 2 million people. They need your software, or your work will not impact the labor market. And then, for example, it's gonna be a self-employment. The advantage of the NIW, it is also a self-petition with no job offer required, meaning there's no employer sponsorship required. The second one, it is also can be filed under premium processing. The third, the most advantageous of the NIW is that you can avoid the prolonged labor certification process. Now, I'm going to hand over the slides and the discussion to Namada.
All right. That brings us to the last part of the webinar session. Let us quickly dive into the section pertaining to some of the most frequently asked questions. The primary question of them all would be, I've heard that President Trump will make the H-1B program harder. Can you explain the changes? I think you're on mute, Liliana.
Oh, I'm sorry about that. There is a speculation that the new administration may implement stricter rules for the H-1B program, but it's still too early to know for sure. We will closely monitor any updates and continue providing excellent immigration legal support assistance and its employees.
Okay, the next one would be, my son is 18 years old and my EB3 priority date is far away. What happens if he turns 21 before my priority date becomes current?
Yeah, if your priority date isn't current by the time your son turns 21, he may age out and no longer qualify under your green card application. However, the Child Protection Act might help by freezing his age during certain parts of the process.
All right. The next would be, can I have an I-140 approved for EB2 and at the same time have another one filed by the same employer for EB1C?
Yes, it's possible for an employer to file multiple I-140 petitions under different categories for the same employee. These petitions are independent of each other.
Okay. For EB1C, how can I prove that my position abroad was managerial or executive? If I oversaw teams or projects, but I didn't directly supervise employees.
Yeah, you can show that you manage an essential function of the organization, set goals, oversaw budgets, or influence high-level decision-making. This is called a functional manager.
The next one would be, I'm on H-1B. Can I work for Systemsoft International subsidiary for 1 year and leave my wife and kids on H4?
Well, no, because you will no longer be employed by Systemsoft Technologies LLC in the US. Your H-1B status would end, and the H-4 for your spouse and minor children would also no longer be valid.
All right. I had a technical job title in India, but my duties were managerial. Can I still apply for EB1C?
Yes, I'll take this one. So the focus is on the duty, not on the job title. So you will need to document that your responsibility were managerial or executive, such as overseeing teams, budget, or key functions.
Okay. I have a pending 485 sponsored by my employer. Can I not work for my sponsoring employer when I get my green card?
Okay, so there's no specific timeline or regulation stating that by law that indicate how long you must remain with your sponsoring employer. However, the job offer need to be true and permanent. It's generally recommended that you work for the sponsoring employer for at least 6 months, so that to avoid the future complications.
Okay. The next one would be, if NIW and EB1A do not need a sponsor, can I work for any entity when I receive my green card?
Yes, you can, because EB1A and NIW doesn't need a sponsorship. So as long as you are working in the same field of expertise in your petition, you should be okay.
All right. The next one would be, can I work for different or multiple H-1B employers at the same time?
Yes, you can, as long as each of your employer has a valid H-1B petition. However, it might be risky sometimes because the USCIS may question about the legitimacy of each job and then how you can work on multiple jobs during the hours.
Okay. Do I need to file or renew my wife's or kids' H4 at the same time when I change my H-1B employer?
Yes, we got these questions a lot. So it's not required to file the H-4 extension every time you file change of employer for your H-1B. However, and then H-4 status is not employer specific. However, it is advisable to file in order to keep the expiration date consistent.
Okay. When does one may need to file Form I-824?
I'll take this one. Form I-824 is used to request additional actions on an already approved immigration petition, such as requesting a duplicate approval notice or sending an approval notice to another consulate.
Sure. The next one would be, can I file for 824 and 485 together?
No, you cannot file Form I-824 and Form I-485 adjustment of status together. Again, Form I-824 is typically for cases where the applicant has already received an approval notice and needs further action, while Form I-485 is for adjusting the status of permanent residency.
Sure. What are the steps that one must take if they lose their green card? And how long does it take to get a new green card issued?
So if you lose your green card, you can file a form that is called the I-90 application to replace permanent resident card. The current processing time is 20 months, but the receipt notice will automatically extend your permanent residency status.
All right. Can one switch employer while on 485 EAD? And what are all the protocols that one needs to be followed to be more cautious about?
Yeah, good question. Yes, you can switch employers if your I-485 has been pending for more than 180 days and the new job is in the same or similar occupation classification. You do so by filing Form I-485 Supplement J to notify USCIS of the job change and ensure compliance with reportability rules.
All right. Will I be questioned by the USCIS officer during my citizenship interview if I never worked with the employer who sponsored my immigrant visa, like EB2 or EB3? The second part of that question will be, will my citizenship be put on hold if I never worked with that immigrant visa sponsoring employer?
So this is a great question. Yes, the officer will likely ask you if you work for the employer who sponsored your green card, as they want to confirm that you got the green card lawfully. If there is any doubt or missing information, the case might be put on hold for further investigation, and you could either receive a request for additional evidence, a notice of intent to deny, or even be asked to attend a second interview. Under these circumstances, I strongly recommend you to hire an experienced immigration attorney even before applying for citizenship, so he can make an analysis of your case and the situation.
Right. And in case post the citizenship interview, if my case is withheld on the grounds of further investigation and I haven't heard back from them, say, for instance, about 3+ months, what might be the possible outcomes from the USCIS side? And additionally, what are the steps that I can take from my end?
Well, USCIS could be verifying your background, employment, or other details. If it's been over 120 days, you can inquire with USCIS for updates through the USCIS contact center by calling or filing electronically the inquiry. Thank you, Namara.
Thank you.